In this video, I'm going to talk about negligence per se. Not negligence, but negligence per se, a different type of negligence, which is based on statutory or regulation violation. Let me roll About Me tape, and then I'll be back on the other side. Hello, my name is Kasey Shah. My slogan is a lifelong learner and a passionate teacher. I'm admitted to California Bar as well as US Patent and Trademark Office. My goal is to help you prepare and pass law exams. Thank you. All right, I'm back, and let me walk you through negligence per se doctrine. So this is not a very difficult doctrine to understand, but you have to apply it carefully for your law exams, whether it's a first-year law school exam or bar exams. So let's see, what's the rule statement for negligence per se? So under the common law, negligence per se is a doctrine that establishes a defendant's negligence due to violation of a statute or a regulation designed to protect. It has to be designed to protect a certain class of persons from a specific harm. So let's look at the elements of negligence per se. Statutory violations. Anytime you see somebody is breaking something, statutory violation, you can look at negligence per se. So it has to be some sort of either law or regulation that they have violated, like traffic law, for example. Then negligence per se is at play. Has to be protected class. So the plaintiff is within the class of persons to whom the statute intended to protect. So if it is a traffic law, then it has to be people who are protected from traffic-related accidents and mishaps and things like that. So those are the protected class. Third element here is type of harm. The type of harm suffered is a type the statute aims to prevent. The statute has to be enacted to prevent this type of harm that the defendant is claiming. And last element, causation. Causation has to be the statutory violation proximately caused the plaintiff's injury. So the violation of that statute was the proximate cause of that injury, has to be proven for negligence per se. So let's take a look at an example. Driver runs a red light, violation of a traffic law, and collides with another vehicle. The injured party can claim negligence per se because the driver violated the statute intended to prevent such accident. So does this example have all these four elements? Statutory violation, yes. Traffic violation, this is element number one. Protected class, so the defendant here, injured party, is the one who collided, right? So that's the party. So this party was one that statute, traffic law, wanted to protect. So they are part of the protected class. Type of harm, it says here, intended to prevent such accidents. It's running of a red light. So the law was about, traffic law was about not running the red light. So that's the type of harm. That's number three. This is number two. And causation, you can prove that because of this number one, someone broke this traffic law of running the red light. That was the causation of the accident that happened in this case. So the number four would be driver runs a red light and collides. This is the causation. That's number four. It has all the four elements. This is a case that talks about, it's a pretty old case, 1920, where plaintiff was driving without headlights at night, violating the statute. That's number one. The court held that violation constituted negligence per se, and the plaintiff's failure to comply with the statute contributed to the accident. So that's how negligence per se works. Pretty straightforward and not very complicated, but it does not have your standard negligence analysis where you have duty, breach of duty, causation, and harm. You have some of them, but not all of them. There you have causation here, just like negligence. You don't have a duty and a breach because of the violation. That's the difference. Okay, I do have a short essay for you to look at and answer. And this is my framework that I use for all my training, and I used it for my own preparation when I went through the bar exam. It's really helpful. Short essay, I create like a very short fact pattern, and I have you to answer. Olivia owns a dog. She often lets roam without leash, right? This is without leash, despite city ordinance. Whenever you see that, that's the negligence per se potential, requiring all dogs to be leashed in public area. One day her unleashed dog bites Patrick, a jogger in the park, causing serious injuries. Patrick sues Olivia for negligence. Here, duty, breach, causation, harm you can do standard negligence analysis and you'll fall short of it. Because it's an ordinance, you can straight away go to negligence per se. That's where statutory violation. Analyze Olivia violated statute, pretty straightforward. Was a city ordinance, yes, she violated the statute. Protected class Patrick was one that statute intended to protect from the unleashed dogs. He was in the park, jogging in the park, jogger in the park, as you can see here. Type of harm, Patrick was bitten. As to the type of harm, assess whether Patrick's injuries are the type statute intended. Yes, putting a leash on the dogs would have prevented, and that's the type of harm that statute intended to prevent. Was the causation and the liability? You can analyze that. There is pretty obvious causation and liability here on part of Olivia. My recommendation approach is take such simple, short fact pattern, write just a couple of sentences for this, just 2 sentences for each one of this. You will become much better in analyzing fact patterns and get more confident for your essay writing. The whole technique I cover in other videos on my platform at hellolawacademy.com. Short quiz, similar approach I take here is very short quiz just to make sure that you understand the concept. This is not a very difficult concept, but I do this for all the concepts. So negligence per se short quiz. Did Olivia violation of the leash ordinance constitute negligence per se? Yes, we talked about that. Is Patrick within the class? Yes. Can Olivia argue that Patrick's injuries were not proximately caused? Can Olivia argue by her violation of the ordinance? Yes, if Patrick provoked the dog. This if is important. Otherwise, no. If Patrick did not provoke the dog, then no. Otherwise, Patrick, if he provoked it, then that's on him. The causation then switches back to Patrick. Patrick was the reason, not the violation of the ordinance. Does negligence per se automatically make Olivia liable for Patrick? Not really, because she may have valid defenses. So let's say no, because she may have valid defenses. Yes, because violating is not automatic. If all elements of negligence per se are satisfied, even when all elements are satisfied, there may be defenses. Always look for that last option. Defenses are still there. She may go to the defenses. I do have a 2-people podcast on this document. It walks you through in a podcast format in audio, so you can have that. I don't have any notes, additional notes here. Let me use my whiteboard just to make it clear for you for negligence per se. So in negligence, let's say normal negligence, you have duty, you have to prove breach of duty, then you have to prove causation, direct and proximate, and then you have to see injury or damages. You have to prove that. Now, if you can, yes, 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 and yes, then you have negligence proven. If not, you should look for negligence per se analysis. I call it NPS in this case. Here we look at the elements we talked about. Is there an ordinance? Is there a statute? Is there a regulation? Something was enacted. Is type of harm that this wanted to protect. For example, let's say there is this same red light running traffic accident happened. Then if somebody sues for defamation, that's not related. That's not the type of harm that, because argument started and then somebody said something bad about them and they now sue for defamation. How to prove defamation? They can't rely on negligence per se for that, right? So type of harm must be the one that the statute intended to protect. Then you have to look at whether that person was the one that was supposed to be protected class. So it has to be pedestrian or driver or somebody. It can be somebody flying a plane that got affected somehow by this road accident, and they're claiming this negligence per se. No, it doesn't make sense. And then we have to also look at the causation, not the harm, but the causation. Was it an intervening cause, or what actually caused that accident or that breach of duty in this case? So that's how you analyze negligence per se. Not a very complicated concept, easy points for you for any of the law exams, whether FYLSE, bar exam, or your college exam. Just go get it. I'm going to make these documents available as they are annotated on the platform at hellolawacademy.com. If you have any question, email it to me, Kasey at hellolawacademy.com. Thank you very much. Signing off, Kasey Shah.